Welcome to the 2018 edition of Shareholder Proposals, Trends, Strategies, and Tactics. My name is Cam Hoang, and I am a partner in the corporate group in the Minneapolis office, and I'm joined today by my partner Gary Tygesson and our associate Nicole Strydom. So we have a busy agenda today. First of all, we're going to review 2018 proxy season trends and developments, and then we'll look forward to expectations for the 2019 proxy season. Then we'll dial back and talk about some basics for responding to a shareholder proposal, the process for including a proposal in the proxy statement, and then alternative bases and process for excluding a shareholder proposal for those companies that choose to go down that path. So starting off with 2018 proxy season trends and developments. Overall, we saw fewer proposals submitted this year, 788, which is down from the all-time high in 2015 of 943 proposals. However, we also saw higher levels of overall support. Average votes cast for proposals increased to 32.7%. Many proposals were withdrawn or excluded, and we also saw less no-action relief granted. We saw declining levels of no-action relief across the most commonly cited grounds for exclusion, including conflicting proposals, challenges to eligibility and procedural defects, substantial implementation, ordinary business, and vague or misleading proposals. Turning to the most commonly submitted types of proposals, as we look at this chart compared to last year, we're seeing the same issues, except that proxy access has dropped off significantly. Special meeting and written consent proposals, in contrast, tripled from 2018, thanks to filings by John Chevedden, Jim McRitchie, and affiliates.
It's interesting to note here that once again we've seen environmental and sustainability issues topping the chart. So this seems to be the new way of the world, Cam.
Yes, absolutely right, Gary. I don't think they're going anywhere. Proposals receiving at least 30% of votes cast on average included the elimination or reduction of supermajority voting, majority voting for directors, shareholder written consent, shareholder right to call special meetings, and climate change. All of these proposals were well supported last year too. Proposals that averaged 30% last year but not this year included independent chair proposals, board diversity, limiting golden parachutes, and executive stock retention. And though proxy access and board declassification did not receive 30% average support, there were still certain proposals that passed this year. Other issues receiving majority support for certain proposals included sustainability reporting, reports on opioids, and reports on gun violence. It's interesting to note that 2 years ago, 2 board diversity proposals received more majority support. However, none received majority support in 2018. Turning to governance proposals specifically, we saw similar numbers of proposals filed in 2018 versus 2017, and a broad variety of proposals receiving majority support, including declassifying board terms, adopting proxy access, and adopting majority voting in uncontested director elections. These are mature proposals on practices that have become widely accepted among large cap companies, and so it's really the outlying companies that are being targeted. For example, approximately 70% of the S&P 500 have already adopted proxy access. And so it's no surprise that we did also see a resulting big decline in proxy access proposals. Turning to environmental and social proposals, we saw large numbers of these proposals in 2018, similar to in 2017. 72 proposals filed on climate change, but only 20 voted on, so a large number of them being negotiated out or excluded. And the topics in these proposals included reports on the business impact of the Paris Accord, methane emissions management, and adoption of GHG reduction goals. Support was strong, averaging 32.8% of votes cast, like in 2017, and we saw 4 of these proposals pass. Support from major institutional investors played into the strong showing for these proposals, as well as the recommendations of ISS. ISS actually recommended for 90% of these proposals. And apparently, shareholders aren't the only parties interested in climate change reporting. Last Monday, Senator Elizabeth Warren introduced the Climate Risk Disclosure Act, which directs the SEC, in consultation with climate experts at other federal agencies, to issue rules within a year that would require every public company to disclose, among other items, its direct and indirect greenhouse gas emissions. On the other side of the debate, the National Association of Manufacturers and Main Street Investors Coalition launched a campaign to limit companies' engagement on ESG shareholder proposals, and they are asserting that these proposals further political versus business interests. This has been an extraordinary 12 months for board diversity initiatives. So we saw 30 proposals filed, but only 3 voted on. Again, a large number of these negotiated out. These proposals called for the adoption of a board diversity policy or a report on board diversity. Support was also strong, 25% of votes cast, which is a slight decline from 2017. None of the proposals passed, however. And what we're seeing is that withdrawals were negotiated based on the adoption of new or revised policies, including the Rooney Rule, which commits the company to including diverse candidates. Like with the environmental proposals, we're seeing significant support from major institutional investors and from ISS, which supported 100% of these proposals. So there are a lot of really significant developments in this area. We saw a majority female distant slate of directors prevail at destination maternity. As Gary will discuss, institutional investors are voting against members of nominating committees at companies with few or no women directors. And we're seeing a California bill that would require publicly traded companies headquartered there to have at least 1 female director by the end of 2019, and at least 2 to 3 at the end of 2021 for companies with 5 to 6 plus directors on their boards. Now, while quotas have not been broadly supported in the U.S., we have to take into consideration the context of this bill, and that 25% of these companies headquartered in California currently have no women directors. ISS recently released its report on annual governance principles, and the survey noted that more than 80% of investors and more than 60% of non-investors consider it to be problematic if there are no female directors on a public company board, and this is actually a big jump from the survey results from last year. We're also seeing a large number of proposals and stronger support for workforce diversity and gender pay equity. Once again, note the theme of a large number of negotiated withdrawals. And we can see why it's in many companies' interest to negotiate versus oppose these proposals, because not only do they risk a PR hit by opposing them, but there's also employment relations consequences when they choose to stand up against these proposals. Turning to compensation proposals, we saw an interesting development in that there are social issues being packaged as compensation issues. And what we're seeing there, pharmaceutical pricing proposals, cybersecurity proposals, legal compliance proposals, all linked to performance metrics for executive officers. And proponents are tying business practices to their impact on executive compensation because it has been shown to be successful in defeating the ordinary business no-action request that companies frequently will file in connection with social issue proposals. Another trend that we noted is lower say-on-pay support and higher failure rates. So Alliance Advisors reported that average support for say-on-pay proposals through May of 2018 of 91.2% was trending lower than in 2017 when it averaged 92.6%, and the failure rate more than doubled to 2%, including many companies in the S&P 500. A recent development has been the shifting role of proxy advisory firms. So ahead of the upcoming roundtable on the proxy process, which is scheduled for November 15th, the SEC staff has withdrawn 2 no-action letters that provided comfort to investment advisors in relying on proxy advisory firm recommendations. The withdrawal of these no-action letters will open up for discussion the role of proxy advisory firms and the circumstances in which investors may rely on their recommendations. These withdrawals were made to open up discussion. In addition, CII believes that the SEC wished to preempt lobbying in Congress to nullify these no-action letters, creating a precedent to undermine staff guidance generally. So thanks to Danette Smith at UHG for sending us that alert.
This is really kind of a new and exciting development and kind of a big deal, Cam, isn't it?
It really is. And so when we look at it, I think we'll be seeing a lot of coverage around the November meeting. So companies will be pondering what is the practical consequence for the upcoming proxy season. And what we would say is that most larger institutional investors already have implemented their own proxy voting guidelines and processes, so we don't expect the withdrawal of these no action letters to have a significant impact on them. Smaller investors may need to bolster their own voting policies and processes going forward. And it's also interesting to ask, so how influential are these proxy advisory firms? This is definitely an ongoing debate, and we'll see more back and forth here. But research has shown investor voting decisions often are highly correlated with proxy advisory firm recommendations. There was a recent Manhattan Institute report that showed 95% of institutional investors vote in favor of say-on-pay when ISS recommends for it, but only 68% vote in favor when ISS is opposed. And so we've done a recap of the 2018 proxy season. I'd like to turn it over to Gary to see what to expect in 2019.
Thanks, Cam. So now we get to gaze into the crystal ball for a bit and talk about what we see for 2019, which is coming up on us very quickly now. Let me say at the outset that this is much more of an art than a science, but this is our third year of doing this webinar, and we actually have a pretty good track record of making predictions. So here goes. First, I would have to say that for many companies, shareholder proposals will continue to demand a significant amount of time and attention. While the overall number of shareholder proposals has been declining in recent years, and we expect that trend to continue, the pain factor will still be pretty high for a number of reasons. Average support is increasing overall. The number of proponents is increasing, and they are a much more diverse group. We're seeing much greater traction among mainstream institutional investors. The scope of subject matter for proposals is expanding, especially in the environmental and social areas, and we're seeing groups composed of very different investor types coming together around narrow issues. For example, this past year we saw coalitions form around some interesting proposals, such as opioids and the impact of TV on children. And while I wish I had better news, I don't see any relief in the near future coming from initiatives to reform the shareholder proposal rules. Second, the ability for companies to successfully exclude shareholder proposals will be difficult. We saw strong exclusion success rates based on several rounds in 2018, including substantial implementation and micromanagement-focused ordinary business, and a renewal of the successful use of the conflicting proposal exclusion. But the overall success rate on no action requests has been declining as proposals are more artfully crafted and technically compliant, and as the staff seems to be tightening the reins on no action letter requests. We were all disappointed and a bit confused this past season by the staff's application of their new board analysis guidance in Staff Legal Bulletin 14I for certain ordinary business and economic relevance no action requests. More about that later. And vague and false and misleading exclusions are all but dead. This has never been a very fertile ground for exclusion, and this year the staff turned down all requests on that basis, including, my personal favorite, Boeing's request, where for some reason the staff was unable to conclude that referring to the directors as lapdogs did not impugn the character, integrity, or personal reputation of Boeing's directors. So with the expectation of continued pressure from shareholder proponents and continued difficulty in excluding proposals, companies should be thinking about strategies for potential engagement and negotiation with proponents. Proposal withdrawal rates are showing a marked increase even following the submission of a no-action letter request, especially on environmental and social issues, if companies are willing to engage with the proponent. Investors increasingly view shareholder proposals as an invitation for dialogue, and engagement with proponents may reveal common ground. In terms of the types of proposals to expect in the coming year, we think that environmental and sustainability issues will continue to emerge as mainstream investor concerns. We expect to see more proposals on a wide range of topics related to climate change, and more proposals on a variety of other environmental issues. And we expect to see increased shareholder support as mainstream institutional investors climb on the bandwagon. Cam, I see no downturn in the recent increase investor focus on board diversity. The New York City Comptroller's Board Accountability Project, which brought proxy access into the mainstream in a matter of just a few years, has now turned to board diversity as a primary focus of version 2.0 of the Boardroom Accountability Project. BlackRock, CalSTRS, CalPERS, Glass Lewis, and others have adopted proxy voting guidelines favoring board diversity. And as you mentioned, Cam, the state of California has jumped into the act with their recently adopted legislation. It will be interesting to see how that plays out and if other states follow suit. Investor focus will also continue to increase on other social issues. At the top of the list, I think we'll see a lot more proposals on workplace diversity and discrimination, equal pay, and the pay gap. The use of social and environmental performance measures in executive comp, and social and environmental qualifications for director nominees. I would also expect to see a continued increase in the level of shareholder support for proposals on social issues, especially where investors see them tied to the long-term financial success of the company. Proposals relating to governance, political and lobbying activities, and executive comp will continue at similar levels experienced in 2018. Governance proposals will remain a major category of proposals, second only to social and environmental issues. While we haven't seen it yet, a new governance issue du jour may emerge to take the place of the hot topics we've seen in recent years. Proxy access was huge in 2015 through 2017, and shareholder special meeting rights was big last year. At this stage of the game, nobody has signaled a shot as to what might be new for 2019, but we'll keep an eye on that. Independent board chair proposals will likely continue to be in the top 10, and watch for executive comp proposals to continue to evolve as a vehicle for advancing social and environmental issues. We expect that proxy access proposals will continue to wane, both for proposals to adopt proxy access bylaws and proposals to amend existing proxy access bylaws. If you're in the 30% of the S&P 500 companies that have not yet adopted a proxy access bylaw, you may be vulnerable to a proposal to adopt a proxy access bylaw. You could also be at risk for a proposal to amend your proxy access bylaw if your bylaw varies significantly from the 3/3/2020 market standard.
Gary, are you seeing these proposals trickle down to small and mid-cap companies?
Well, you know, Cam, that's what we would expect, as most of the S&P 500 has already gotten on board, either voluntarily or through a shareholder proposal. But quite frankly, the steam seems to be coming out of that initiative as the New York City Comptroller's Office and other institutional investors seem to have their sights set on other targets. I think we will continue to see some of these for smaller companies in the year ahead. We also expect that shareholders will increase their use of exempt solicitation filings to publicize shareholder proposals that are up for a vote. Rule 14a6G requires a shareholder who owns more than $5 million of a company's securities and who solicits shareholders on a topic but does not seek a proxy to file a notice of exemption which automatically appears on the company's EDGAR page. We've seen a lot of shareholder filings of these notices in recent years in response to a company's statement in opposition to shareholder proposals. And we've seen it in other contexts as well, such as say on pay votes or a vote no campaign against directors. Even shareholders who own less than $5 million in shares have been filing these statements, so-called voluntary filers. This is a great way, and some might actually say a sneaky way, for proponents who own very little stock to get their message out there on the company's very own website, and they often contain questionable content. These postings can be very confusing. They can look like it's the company's position or the position of a substantial shareholder, when it's just John Chevedden. To try to clarify that, the staff issued CNDIs in July of this year that require voluntary filers to indicate that they own $5 million or less of the company's stock. In addition, all filers must include a cover page that identifies the party making the exempt solicitation. Companies should actively monitor these filings for potential abuses and respond where necessary. Finally, Cam, there are some changes in the legal requirements for shareholder proposals under consideration, but they're not likely to be adopted in time for the 2019 proxy season. The Financial Choice Act 2.0, adopted by the House in June 2017, would have amended Rule 14A8 to increase share ownership thresholds for submitting shareholder proposals, increase resubmission thresholds, and prohibit proposals by a proxy other than a shareholder. But the Senate version passed in May and signed into law did not include the proposed amendments to Rule 14A8. In June, the House Financial Services Committee passed H.R. 5756, reviving the resubmission thresholds to allow exclusion of proposals that were previously voted on in the past 5 years. We'll just have to see if that bill gets traction in Congress. Meanwhile, SEC Chairman Clayton, the National Association of Corporate Directors, and the U.S. Chamber of Commerce all support reform. And we'll be watching for outcomes of the SEC's Proxy Plumbing Roundtable on November 15th. Agenda items for that roundtable include the shareholder proposal process, as well as proxy voting mechanics and technology, and the role and regulation of proxy advisory firms. I also want to note for everyone that recently in April, the Department of Labor came out with guidance on ESG proposals. The April guidance clarifies that fiduciaries must not too readily treat ESG factors as economically relevant to a particular investment choice at issue when making a decision. In addition, they should not routinely incur significant expenses to engage in direct negotiations with the board or management of publicly held companies. So we'll see if this guidance has a chilling effect among investors who are subject to these rules in the level of support and the level of engagement for ESG proposals in 2019. That's about all I'm seeing in the crystal ball for the coming proxy season. So let's move on to talk about what to do if you should receive a shareholder proposal. Nicole?
So I'll start with the basics of responding to a proposal. And while you will obviously be focusing on proposals included in the company's proxy statement, for general reference, proposals outside of a company's proxy statement must be submitted in accordance with state corporation laws and a company's organizational documents. And proposals included in the company's proxy statement must comply with Rule 14A8 of the Exchange Act. When can shareholder proposals bind the company? Proposals are typically non-binding because under most state corporation laws, shareholders do not have the power to require the board to take action on the basis that it would interfere with the board's ability to govern the affairs of the corporation. But there are instances when shareholders may invoke their power under state law to adopt bylaws in order to make binding proposals. To refresh your memory on who is actually eligible to submit a proposal, the first criterion is that shareholder proposals may be filed only by an investor who has held at least $2,000 worth of the company's stock or 1% of the shares eligible to vote, whichever figure is smaller, continuously for at least 1 year before the date the proposal is submitted to the company. The next criterion is that the proponent must pledge to continue to hold the securities through the date of the annual meeting and not just the record date for the meeting. While these criteria haven't changed for a while, eligibility requirements would change if the Financial Choice Act 2.0 is adopted. When must the proposal be submitted? Typically, shareholders must submit the proposal by the deadline disclosed in last year's proxy statement, which is at least 120 days before the date of the company's proxy statement for the previous year's annual meeting. And must a company accept a revised proposal? Only if that proposal is submitted before the deadline. Do website addresses count against Rule 14A8D's 500-word limit on shareholder proposals? A reference to a website address counts as 1 word, but the information contained on that website does not count against the word limit. The website may, however, be excluded if the information contained on the website is materially false or misleading, irrelevant to the subject matter of the proposal, or otherwise in contravention of the proxy rules. Do graphics count against a proposal's word limit? On November 1st, 2017, the SEC Division of Corporate Finance issued a Staff Legal Bulletin number 14I, otherwise known as Slab 14I, addressing, among other topics, the use of graphs and images consistent with Rule 14A8D, which we'll discuss further on the next page, and the eligibility of proposals submitted on behalf of shareholders, which we'll also discuss later. Slab 14I stated that the inclusion of graphs and/or images in proposals outside of the 500-word limit is not prohibited, but words contained in graphics count towards the limit. Nevertheless, similar to websites, Rule 14A8I3 permits exclusion of graphs and/or images where they make the proposal materially false or misleading, are so vague that stockholders can't determine what they're voting on, impugn character, or are irrelevant to a consideration of the subject matter of the proposal. Moving on to the process for responding to a proposal, first you'll need to establish key deadlines for responding to the proposal and see the sample timeline which we've included in your materials. Next, confirm the proponent's eligibility and procedural compliance with proxy rules. You'll need to ensure that they have complied with ownership and timeliness requirements, as we've discussed above, that there's only one proposal per shareholder for a particular shareholders meeting. The proposal plus accompanying supporting statement may not exceed 500 words. The company must notify the proponent of any deficiencies and a time frame for response within 14 days of receipt of the proposal. If the proponent fails to respond within 14 days of receiving the company's notice, the company may then submit a no-action letter requesting the right to exclude the proposal. And notice does not need to be given for deficiencies that cannot be remedied, such as failure to meet the proposal's deadline. Back to Slab 14I on eligibility. Submission of proposals through a representative is allowed as it is consistent with Rule 14A8. But in light of concerns about eligibility to submit proposals, going forward, the staff will look for documentation in accordance with the following list. Do note, however, that this is not a new foot fault, and materials that allow a reasonable conclusion of eligibility are going to be sufficient.
So Gary, what's driving the SEC's new guidance on eligibility?
Well, it seems a little bit picky here, but I think what the staff was getting at was if you're going to make a proposal, you need to be aware of the basic rules. And I think they've been receiving a lot of proposals are just generated off of a word processing machine. Care is not being taken. And if you're going to engage the company in this dialogue, you should at least be meeting these minimum requirements. A lot of time, effort, and expense goes into responding to these requests, and I think that the staff is aware of that, and they're throwing one to corporate America here saying, let's make sure that shareholder proponents are at least minding the basic rules and making sure that companies have something in which they can respond.
So going back to the process for responding to a proposal, you'll want to identify goals if you decide to engage with the shareholder and realize that there is a range of responses. Below is the potential spectrum of accepting versus shouting down the proposal, such as advancing the company's position on the issue, strengthening relationships and reputation with shareholders, collaborating with shareholders on further study of the proposal, discouraging future proposals, minimizing disruption to board and management processes. Gary or Cam, what should companies be thinking about in this context?
Well, Nicole, as we look at this spectrum of shareholder engagement, you really go from either embracing and aligning with the shareholder and working with them on a common cause to being oppositional. One observation I'd make is that the amount of time and effort that is needed to engage with the shareholder these days versus opposing the proposal may actually be quite similar. More and more, simply putting a proposal in the proxy statement or seeking it to exclude it is not the end of the matter. So, shareholders will use exempt solicitations, as Gary mentioned. They'll submit very detailed responses to no action requests to the SEC to continue the dialogue. And then, the other thing I would say is that obviously proposals do not occur in a vacuum. So the shareholder engagement has to be one small piece of a larger business strategy often. And the example I would point to is at Nike. So there was a political contributions reporting proposal that just went up for a vote there last Thursday. It did not pass, but this proposal occurred in the context of the Colin Kaepernick advertising campaign that was unveiled just weeks before that, where Nike really just doubled down on its political engagement and saying to the world, we're not concerned or we're not afraid to take a position on hot button issues.
Their stock price did well.
Yeah, for sure. No one's going to argue with that. So 35% increase year over year is very, very positive. Gary, what do you think about the strategy for shareholder engagement?
Well, this is really where it gets interesting, and when you're looking at the shareholder proposal, it really requires the legal team to be fully engaged with management and ultimately with the board of directors on developing the strategy. And the first step, of course, is to analyze the various issues and bases for exclusion, but it has to be taken in a much broader context of what would management support, how far down the road do they want to go in the engagement process, and ultimately what's the board's view on the particular issue, and how are they going to feel about putting in a statement in opposition as opposed to supporting the issue or trying to negotiate it away prior to the annual meeting. It's also part of a much broader conversation that's going on now between companies and shareholders. The shareholder engagement process has really evolved in recent years, and for many companies it's a year-long process. So you're likely to be in almost constant communication for some companies with key shareholders. In other situations, it might be a once-a-year check-in. But in any event, there are these conversations that are ongoing, and to the extent that shareholders are raising these issues in the engagement process, management is going to be much more sensitive to them, as will the board, and that will, I think, dictate a lot of the decisions that are made and the path that's taken.
Yes, for sure. A lot of parties involved in this process.
This slide is a resource for you to use as you plan your strategy for responding. As we've discussed, there are a range of responses, and some of them are set forth here in the flowchart. These potential responses include preparing conflicting management proposals, negotiating with the proponent, presenting the proposal at the annual meeting, and submitting a no-action letter to exclude. Now getting down to some of the nitty-gritty details of including a shareholder proposal. First, the company must send the proponent a copy of its opposition statement no later than 30 days before it files its definitive proxy statement, or no later than 5 days after the company receives a revised proposal. And the proponent may challenge any false or misleading statements. The proxy statement must include the shareholder's name and address, as well as the number of the company's shares held. As an alternative, the company may instead include a statement that it will provide the information to shareholders promptly upon request. If the proponent or a qualified representative fails to appear and present the proposal without good cause, the company will be permitted to exclude all of the proponent's proposals for any meetings held in the following 2 calendar years.
So, as Gary discussed previously, exempt solicitations have become more frequent in the proxy landscape. And so when companies are faced with an exempt solicitation filing, they also face a decision on whether or not to respond. So a few legal considerations for companies that choose to respond to a communication from shareholders subsequent to the proxy filing. Number one, an amended or supplemental filing is likely required for the company. The SEC has taken the fairly broad position that websites, email correspondence, scripts used for oral solicitations are all considered proxy soliciting materials and really need to be filed at or prior to their use. Companies should also keep in mind that they need to post materials on the same website as the original proxy materials, no later than the day that the supplemental material is first sent or made public. And they also face a decision on what further steps should be taken to disseminate the information to shareholders, because while a mailing of the supplemental materials is not required, it may often be the most effective way to really get the company's message out. So, Gary, just taking a step back, what are some considerations that companies should keep in mind when they are trying to decide whether or not to respond to an exempt solicitation?
Well, I think the first reaction that companies have is one of, how did this get on our website? So just being able to, for the legal team to be able to advise management of the rules and how this works is important. Secondly, they need to review the content of the posted document and make sure that they're comfortable with the overall content. I think the recent C&DIs that came out from the staff will help in a couple of areas. First of all, it will be clear from the filing who filed it. In some cases, it's been very confusing. In some cases, it looks like the company actually posted this on their own website and that they are in favor of the shareholder proponent position on this or against management position. So it can be very confusing. I think the CD&Is will help to address that. But at the end of the day, they need to look at this filing overall and say, is it clear who this is being made by? Is the content fair? And if not, do we want to take extra steps to try to correct this? Sometimes you don't want to pour more fuel on the fire, and sometimes just ignoring it can be the best step, especially if you don't think that this particular shareholder proposal has a lot of traction. But in many cases, I think the better course of action is going to be for the company to respond and file preliminary additional soliciting proxy materials and post it on their website so that they can clarify the company's position on this and try to undermine or mitigate any PR issues that are brought about by this filing by the proponent.
Thank you, Gary. So now we've shared some considerations about including a shareholder proposal in your proxy statement. I'm going to turn it back to Nicole to talk about steps to take when a company is going to exclude a shareholder proposal.
Yeah, thanks, Kim. If the goal is to exclude a proposal, a company may submit a request for a no-action letter to the staff. More than one basis for exclusion may be and often is cited. A no-action letter from the staff provides its informal view regarding whether it would recommend enforcement action to the SEC if the company takes the course of action described in the no-action letter request. A company must send the SEC a no-action letter request at least 80 days before the date it plans to mail its proxy statement to shareholders and simultaneously provide a copy to the proponent. Keep in mind that the proponent may also submit its own statement to the SEC. The staff will then consider all the arguments and issue a decision, typically within 30 to 60 days of receipt. Shareholder proposals may be excluded for the eligibility or procedural deficiencies that we've discussed before. There are also 13 substantive bases for exclusion under Rule 14a8. In these next couple slides, here are some commonly cited ones. This first slide actually has the three most commonly cited ones, which we'll discuss in greater detail in the upcoming slides. And then on the following slide, you'll see some other grounds for excluding proposals that are also sometimes used.
And now we're going to move on and do a deeper dive into certain of the exceptions for excluding shareholder proposals. And we're actually going to spend a little bit more time on the ordinary business exception today because it's been an important basis in the past and also because of all of the significant developments from SLAP 14I over the past proxy season. And so what we have here for you is a framework for really thinking through the ordinary business exception as it exists currently. And so the first question everyone needs to ask is, does the proposal relate to ordinary business? And so looking back at SEC guidance on this topic, there are two frequently cited considerations for evaluating whether an activity is ordinary business. Number one, whether the tasks are so fundamental to management's ability to run a company on a day-to-day basis that they could not, as a practical matter, be subject to direct shareholder oversight. And number two, whether the proposals seek to micromanage the company by probing too deeply into matters of a complex nature upon which shareholders as a group would not be in a position to make an informed judgment. And this particular point has been the subject of expanded SEC usage to grant no action relief. We'll talk about that a little bit more later on in the presentation. So once we've established that the proposal does indeed relate to ordinary business, then the second question to ask is, does the proposal relate to a significant policy issue? If the answer is no, then exclusion is permitted. If the answer is yes, then further analysis is required. So what exactly counts as a significant policy issue? Well, that's really the secret sauce of this whole analysis. I think that the SEC in its 2016 stakeholder meeting provided some helpful guideposts to say that a significant policy issue involves a matter of widespread public debate. It includes legislative and executive attention and also press attention. So if there is a significant policy issue involved, then we're getting into the additional guidance that the SEC provided in SLAB 14I. Is there a significant connection between the issue and the company's business? And here's where companies are having to consider whether or not they provide additional board analysis as part of their no action request. Where the answer is no, there is not a nexus between the issue and the company's business, then exclusion should be permitted. But where the answer is yes, then the analysis does go on. And so in SLAB 14I, the SEC addressed the following basis for exclusion: the ordinary business exception and the economic relevance exception. And the SEC guidance is that the board is well situated to analyze, determine, and explain whether a particular issue is sufficiently significant. And furthermore, the no action request should include a discussion that reflects that board analysis. Now, not all requests under these exclusions must include board analysis. There are circumstances where companies have historically been permitted to exclude the proposal and they do not require board analysis, and there is no expectation of new board analysis where there is a well-worn path to exclusion under the circumstances. The staff will give greater weight to a more developed analysis in approving the full board versus a committee-only approved analysis. The company should be prepared to describe the specific board processes. Board materials are not expected to be included with the no action request, which is part of the public record. So companies should take care to make sure that the confidential materials are not included. And the staff did say that it's not likely to give much weight to the outcome of a previous vote. So what was the final result of all of this SLAB 14I analysis in the prior proxy season? Companies have been selective, really, in incorporating board assessment into their no action requests. It obviously takes up a lot of time and resources to present a thoughtful assessment. And furthermore, a company's public position on the social issue may not always jibe with the board's assessment. And actually only one no action request has successfully relied on a board assessment to exclude a proposal on economic relevance grounds, as we will discuss later. Through its responses to no action requests, the SEC has provided context as to when they would like to see a board assessment and where a board assessment was insufficient, and hopefully we will receive more guidance in the coming proxy season. But it's safe to say, based on existing responses, that boards should be using detailed analysis and quantitative analysis where it's possible. And despite prior staff guidance on this issue, companies should still address past shareholder votes on the matter. So where there is a significant nexus, there is a connection between the issue and the company's business. The companies can still go for a Hail Mary and ask, does the proposal nevertheless micromanage the business? Does it seek to impose specific methods of implementing complex policies? Because what we saw in this past proxy season is even in the face of a social issue with a significant connection to the company, where there was a strong enough case for micromanagement, the SEC was granting no action relief. And so what type of examples of proposals receive no action relief based on this consideration of micromanagement? We saw proposals requesting that the company prepare a report that evaluates the feasibility of achieving by 2030 net zero GHG emissions and reducing other emissions. We also saw proposals requesting that the company issue a report assessing the feasibility of adopting time-bound, quantitative company-wide goals for increasing energy efficiency and use of renewable energy, also excluded because of micromanagement concerns. So we are seeing more receptivity to these types of arguments in the past, particularly where targets and timelines were called for in the proposal. And they don't have to necessarily be specific targets or timelines, just the very fact that a proposal calls for targets and timelines was sufficient. Given the SEC responses that we have seen in this area, we are seeing very close analysis of the level of micromanagement in tandem with the assessment of the significance of the issue. And so we would not be surprised to see at all the SEC become increasingly receptive to arguments where we see the balance of the micromanagement outweighing the significance of the issue to the company.
And Cam, it seems to me that in the Amazon and PayPal Holdings proposals that simply eliminating the 2030 net zero standard would have allowed this proposal to go forward. So I think next year you'll see fewer proposals having a specific standard in order to get by this micromanagement analysis.
Yes, that's a good point. Proposals can very easily be revised to get rid of these targets and timelines. And so just a quick rundown on the types of proposals where we saw exclusion still being permitted because there's been a well-worn path towards exclusion of these types of proposals. Sale or distribution of products, proposals that relate to the manner in which a company advertises its products, proposals that would affect the conduct of ongoing litigation, proposals that determine whether or not an in-person annual meeting may be held, charitable contributions to specific types of organizations, proposals in relation to the legal compliance program, compensation that may be paid to employees generally versus compensation to senior executives and directors, discount pricing policies. These are all the types of issues and topics where exclusion has historically been permitted and will continue to be permitted to our knowledge. Turning to the types of topics where exclusion was not permitted in the past proxy season, reports on environmental and sustainability issues, proposals where the SEC specifically noted absent or insufficient board analysis on the nexus to the company's business, reports on racial or ethnic pay gaps, reports on political contributions and expenditures, reports on the extent to which risks related to public concern over drug pricing strategies are integrated into incentive compensation programs for senior executives. So, as we mentioned before, the linking of a social issue to an executive compensation program, cyber risk and cybersecurity, and the establishment of a human rights committee. Turning to the other exception for exclusion that was addressed in SLAB 14I, economic relevance. So this exception permits a company to exclude a proposal that relates to operations which account for less than 5% of the company's total assets at the end of its most recent fiscal year, and for less than 5% of its net earnings and gross sales for its most recent fiscal year, and is not otherwise significantly related to the company's business. So historically, this exception has had limited application because the SEC broadly found relevance where the company conducted any amount of business related to the issue at stake. In the additional guidance in SLAB 14I, the SEC emphasized that the focus going forward will be on the second prong, whether a proposal is otherwise significantly related to the company's business, and that this analysis will be dependent on the particular circumstances of the company. However, substantive governance matters will be viewed as significantly related to almost all companies. Proponents bear the burden of demonstrating that a proposal is significantly related, and the mere possibility of reputational or economic harm will not preclude no action relief. Like the ordinary business exception analysis, companies and boards should be prepared to include a discussion that reflects the board's analysis of the significance to the company and to detail the specific processes employed by the board to ensure that its conclusions are well-informed and well-reasoned. The SEC was careful to note that even though the analysis often has overlap, they will be evaluating the economic relevance exception independently from an analysis of the ordinary business exception. And as we mentioned before, so far there's only been one successful no-action request based on SLAB 14I, which was submitted by Duncan Brand's group, and related to the environmental impact of K-Cups, which the company showed very clearly using quantitative analysis was less than 5% of total assets, net earnings, and gross sales. And so having spent quite a bit of time on the ordinary business exception and the economic relevance exception, I'd like to turn to Gary for a discussion of developments under 14A8I9.
So Rule 14A8I9 allows a company to exclude a shareholder proposal if the proposal directly conflicts with one of the company's own proposals to be submitted to shareholders at the same meeting. The staff redefined this approach under Rule 14A8I9 in SLAB 14H, which came out in 2015. And they now focus on the narrow question of whether there's a direct conflict between the management and the shareholder proposals. The SLAB says that a direct conflict would exist if a reasonable shareholder could not logically vote in favor of both proposals. In other words, a vote for one proposal would be tantamount to a vote against the other proposal. SLAB 14H gives examples of proposals that may be excluded and examples of proposals that may not be excluded under this test. Examples of proposals that may not be excluded included proxy access and compensation. The proxy access example put a shareholder proposal that would permit a shareholder or group of shareholders holding at least 3% of the company's outstanding stock for at least 3 years to nominate up to 20% of directors against the management proposal that would allow shareholders holding at least 5% of the company's stock for at least 5 years to nominate for inclusion in the company's proxy statement for 10% of the directors. So although clearly the standards were different in these two proposals, the staff deemed that you could conceivably vote for one or the other or both of these proposals. And to the extent that one obtained a majority vote, that would be approved. They also had an example in the compensation arena where a shareholder proposal would ask for the Compensation Committee to implement a policy that equity awards would have no less than a 4-year annual vesting requirement. And that compared to a management proposal to approve an incentive plan that gives the Comp Committee discretion to set the vesting provisions for equity awards. And again, in that example, arguably a shareholder could vote for both of them, and if either one of them obtained a majority, they would be put into effect. Big question, what if both obtained a majority? And then you would have an issue in terms of which proposal to move forward with. They also gave examples of direct conflicts that could be excluded. For example, if you're seeking shareholder approval of a merger and there's a shareholder proposal asking shareholders to vote against the merger, you clearly could not vote for both of those. Also, a shareholder proposal would ask for separation of the company's chairman and CEO, and a management proposal seeking approval of the bylaw provision requiring the CEO to be the chair at all times would be directly conflicting and could be excluded. In March of 2016, the SEC staff issued a no-action letter in the Illumina case in which a shareholder proposal that greater than simple majority voting standards could be eliminated and a management proposal seeking approval of existing supermajority voting standards could be deemed to be a conflicting proposal. In 2018, this was one of the most successful grounds for excluding proposals with an 88% success rate, but it was not without controversy, Cam. The staff granted no action relief for 7 proposals to reduce the threshold, calling for a special meeting where the company sought ratification of the existing threshold. No action relief was denied in one proposal where the company did not have an existing provision. This outcome was entirely consistent with the prior Illumina no action letter and SLAB 14H, but the Council of Institutional Investors and some shareholder proponents cried foul, saying this was gamesmanship on the part of the company. Once the company had actually received a shareholder proposal seeking a lower threshold, the company's management could simply put up their own threshold, a higher threshold, for ratification and therefore successfully exclude the shareholder proposal. The SEC responded to this controversy in the Capital One Financial Corp no action letter by, first of all, permitting the exclusion, but secondly, requiring certain disclosures in the proxy statement if the proposal is excluded. The company must disclose that it omitted a shareholder proposal to lower the ownership threshold, and that it believes a vote in favor of ratification of the existing threshold is equivalent to a vote against a proposal lowering the threshold. And since there's no guarantee that the ratification proposal is going to receive a majority vote, the staff also wants you to include in your disclosures what to do if ratification is not received. What will you do with the special meeting threshold, if anything, and what will be the company's course of action moving forward? Last but not least, Rule 14A(I)(10) permits a company to exclude a shareholder proposal from its proxy materials if the company has substantially implemented the proposal. The substantial implementation rule was designed to avoid the possibility of shareholders having to consider matters which have already been favorably acted upon by management. This continues to be one of the most used and successful bases for exclusion, accounting for 1/3 of all exclusions granted and a 66% success rate in 2018. Half of the successful requests related to governance proposals were under the substantial implementation exclusion basis. We continued to see this basis for exclusion used in 2018 on proposals relating to proxy access. The bottom line here is that the staff continues to allow companies to exclude proxy access proposals if the company has already adopted proxy access bylaws that fulfill the, quote, essential objective, close quote, of the shareholder proposal, even where certain details differ. The 3/3/2020 format will typically pass muster under this, but the staff has rejected exclusion requests and proxy access fix-it proposals where the proposal focused on one change, for example, the size of the nominating group and the number of access candidates. So to the extent that those types of proposals are going to be made in the future with seeking to amend or fix an existing proxy access proposal, you can expect the staff is going to reject your no action letter request to exclude that, and you may need to move forward with it included in your proxy statement. However, they have not received significant support in the past year, and we don't expect them to receive significant support going forward.
Thank you, Gary. And so this concludes our presentation for today. As you see, there are any number of trends and developments that promise that the 2019 proxy season will be an eventful one indeed. Please feel free to reach out to any of us if you have any questions or would like to discuss any of these issues. And thank you for your time.